The Alec Baldwin Rust movie shooting trial is underway. Today in the pre-trial hearing, the state and the defense argue several motions that involve certain witnesses and evidence. Baldwin is charged with involuntary manslaughter, where he pointed the gun in the middle of filming a movie and shot a person behind the camera. A lot of people would say, well, he had to have pulled the trigger and pointed a gun at someone, so it's his fault. No matter what, even if there's an armorer on set. The armorer just got sentenced, by the way. She's in jail for 18 months. But some other people are like, he's an actor. A lot of actors don't even check the gun. He's given a prop gun. He trusts in the armor that they didn't put real bullets in the gun. I don't know, dude. This shit's gonna be really tricky. Some people think it's case closed. I don't know. Comment down below what you think. Here we go. Let's get right into this video. That's one of his lawyers right here named Alec, I believe it's pronounced. And then this is Luke Nikas, not sure, on the right, the bald one. So that's his two main lawyers. I think they're both from New York as well. So this is Miss Johnson right here, part of the state.
Mr. Winterstern had not been disclosed by the defense on any of their witness list prior to June 24th. And while they argue that the state had Mr. Winterstern on its witness list in the Hannah Gutierrez trial, we would respectfully submit that that's a different issue. So here, the state did not have Mr. Winterstern as a witness. And so we understand that the defense is claiming that the reason they added him is because the state last minute added this producer theory. However, as the court, I think, noted in one of the hearings that we had previously, this producer issue was known to the defense, and in fact, this is not something that was new to the defense. The state is asking the court to exclude Mr. Winterstern because, number one, we have not been provided with the statement that he is going to be making or has made. We didn't have an opportunity to do a pretrial interview of Mr. Winterstern. So as it relates to this case, the state has no idea what he is going to be testifying about or any previous statements that he made.
The defense did set up an interview that was for our own benefit. We did inform the state that we had set the interview so that as a courtesy, they could come if they wanted to, but it was not something that they requested.
So this is one of his defense lawyers. I would imagine she's in the same law firm as the two guys in the back. I haven't looked into her yet.
Does not request the interview, then it is deemed waived. And at any point they had an opportunity to do so. Actually ask the state if they wanted to amend or add any additional witnesses for whom they wanted to request pretrial interviews. At no time did the state then change their mind and say, yes, we want to interview Mr. Zook. And so that was deemed waived, Your Honor. And we canceled the pretrial interview that we had set for our own benefit, for our own reasons. And so the state cannot now seek to exclude him when they did not take advantage of the process that was available to him. The state claims that the defense recently added Mr. Winterstern to gain some sort of tactical advantage, when really what we have here is that type of behavior on the part of the state. There were a number of different producers. I believe it was 6 different producers on the Rust set. They didn't call a single one to testify. And so it was not clear to the defense. And so at this point, they have 3 different individuals who they're going to call to try to have them testify about what Mr. Baldwin's role as a producer would be. 2 of those individuals have never been a producer before, and the other individual has very limited experience and was not actually on this set, was a witness in Hannah's trial. But not only that, he was the state's witness, and they did conduct a pretrial interview of Mr. Winterstern. And during that pretrial interview, it was actually asked by Ms. Morrissey, Mr. Winterstern's role was as a producer. So we asked Judge, we are just asking for basic fairness and due process. There are other avenues. If the court wanted to give them another interview, they could do that. But again, they've already had a substantive interview of him, and we would ask that the court allow Mr. Baldwin to present this defense.
Your Honor, the issue is the court issued a scheduling order in this case, not in the Gutierrez case, in this case. The court set deadlines for pretrial interviews. It set deadline for witness disclosures. And the fact that Mr. Winterstern was interviewed in the Gutierrez trial does not obviate the need to have a pretrial interview of him in this case. Because in Gutierrez, he was listed as a witness for the state. In this case, the defense is calling him. The state has no idea what he is going to be testifying about. The state has essentially wanton disregard for the safety of others. And his role as a producer made him keenly aware of the safety rules that apply on sets. What his responsibilities are is subject to compliance with established rules of procedure and evidence designed to assure both fairness and reliability in the ascertainment of guilt or innocence. If the state had done this, you know they'd be up here screaming to the court that we have sandbagged the defense. Your Honor, the state is entitled to a fair trial as well. And so we'd ask that the court exclude Mr. Winterstern. Thank you.
All right. Both have pretty good points, but I'm kind of leaning in favor of the defense here.
All right, the court makes the following ruling. The court denies the state's motion. With respect to Mr. I don't think that you've established prejudice, and to the extent that you want them excluded, certainly there are other remedies. I will have the defense make Mr. Winterstern available for a pretrial interview.
There have been multiple civil lawsuits filed against Rust Production and against the defendant himself. Mr. Joel Souza, one of the state's witnesses, filed a civil lawsuit that has, I understand, has since been settled. There are 3 other state's witnesses, or 4, I believe, other state's witnesses who have pending civil lawsuits. We would respectfully ask that the court preclude the defense from cross-examining first Mr. Souza about his settled civil lawsuit. And there's a case right on point, which I cited in the motion, and settled it is irrelevant and should not be allowed. With regard to the other witnesses, Your Honor, although the state respectfully submits there is a distinction between pending civil lawsuits that 4 of the state's witnesses have versus what the court looked at in Santillanes. My understanding is that the pending civil lawsuits that the 4 state's witnesses have to do with intentional infliction of emotional distress and negligence as a whole in the filming or during the time that this filming was taking place between October 6th and October 21. So it's not specifically related to the charge that the defendant is facing. If someone had a pending wrongful death lawsuit, I would concede that that is germane and is subject to cross-examination. But because there is a difference between the civil lawsuits and this pending criminal prosecution, we would respectfully request that the court deny or preclude the defense from questioning these witnesses about their pending civil lawsuit.
Oh, so they don't want any questions about the civil lawsuit side of everything?
Your Honor, the defense has no present intention of questioning Mr. Sousa about his settled lawsuit. I'm not waiving that issue, but I don't think the court needs to get there today. The rest of this issue is quite easy. This cross-examination was done during the Armour's trial, as the court no doubt remembers. In that case, there was zero financial motive. In this case, there is suits against Mr. Baldwin directly, an extreme financial motive. Lawsuits are exactly on point. It almost actually looks, if you look at the lawsuits versus the state's case, like they copied and pasted it. And I know this case seems in some ways like a civil negligence case, but it literally looks like they may have copied and pasted part of the lawsuits. So they're directly on point. None of their cases say what they claim. The case law on this is clear. It's actually one of those issues that's universal amongst all 50 states and all courtrooms in this country. You can always cross-examine a witness about their motive and bias. You can always ask them.
I can already tell this guy's good at his job, bro. I'm already getting that vibe.
And that's what the Confrontation Clause promises us, and that's what the Constitution demands. I don't think
The civil action, and I quote, was for the same offense being tried in a criminal action. Absolutely agree. It would be subject for cross-examination. But I would respectfully submit that there are differences here between the civil actions and this criminal prosecution. So we'd ask that the court preclude any cross-examination.
All right, the court makes the following ruling. Evidence of pending lawsuits against defendant by testifying prosecution witnesses is proper impeachment evidence. The motion is denied.
The judge is ruling in favor of the defense here.
But essentially, the court has the papers. Their response that the state is allowed to burden shift in certain places, that's their sort of strongest response, misses the mark. I mean, even in the case they cite, right, what the prosecutor does, it's one remark in summation, where the prosecutor says, I, of course, have the burden of proof. It never leaves this table. This is a very serious proceeding, and I have the burden of proof. Just so you know, though, you can consider, and then they make one remark. That's the context of any case that goes against these basic propositions that are also the same in every single state. The reason that I had to make this motion is because in reviewing some of the trial, and I haven't been able to get through every bit of it that I want to on this subject, but it's constant issues with controlling the prosecution from doing things that are just straight and proper. And so I don't know what to do in that circumstance. I've never made a motion like this before. It's objection, this witness doesn't know that. Objection, they don't know how to identify the picture. We have plenty of other witnesses. Sometimes it was no objection at all. Sometimes the prosecutor just called out from the prosecution table and started saying, I would request the witness read the entire transcript. He can't answer that. And then there's the questions, and we'll get to this in another mill. Constantly, every single witness, they'd ask a question, what happened next? And where was Miss Hutchins during that? Where was Miss Hutchins? Oh, she was in the helicopter. And then they would go on. And they would ask another question about the chronology. And they say, well, where's Miss Hutchins? She's in the helicopter. And so, this is it's misconduct. You can't do that. You can't do that as a prosecutor. You're not allowed to do that as a prosecutor. It's very serious to do that as a prosecutor.
This trial might be more spicy than I thought it would be. Prosecutor playing a little dirty.
So eventually the court at some point stopped Miss Morrissey.
He's talking about in the Armour trial.
From doing the coaching, speaking objections. And then Miss Morrissey began, every time her name was mentioned in a question, she began to stand up and say, well, I'm being talked about in this question. And she began interrupting the proceedings. So I didn't know how to address this. I don't know how to address this, even as I stand before Your Honor. Request would be objection, relevance, objection, hearsay, and nothing else. And in the very rare circumstance when an issue rises to the level of extreme importance or constitutional imprint, a lawyer can approach. If there's something very complicated, a lawyer can approach. But otherwise, none of those tactics and devices should be used at this trial. We've come a long way to get here. The court has been very patient. All that we want is a fair trial. And for the rest of this, I would rely on my papers. Thank you.
Response.
Your Honor, I think we can agree on one thing. Absolutely, without a doubt, and that's beyond dispute, the state has the burden. And the state cannot shift that burden to the defendant. Absolutely agree. There are circumstances, Your Honor, where the state is permitted to comment on the veracity of a witness as long as it's based on evidence. If the prosecution says, it's my opinion that this witness was truthful, absolutely improper. Absolutely agree. But if it's based on evidence that a witness testified to X and there's corroborating evidence of X, the state is allowed and should be allowed. I would ask that the court not allow the defense to try to imply to the jury that meeting with witnesses prior to their testimony is improper. Coaching, absolutely. The prosecution to tell a witness what to say, absolutely agree. But to meet, to prepare for their testimony is completely proper. And we'd ask that the court not allow the defense to comment on that as being improper.
Well, I have to say, I don't like these kind of motions because I'm not going to be bound by it during trial where someone shows me an order and says this is what I said. I was going to tell you, but I'll tell you now, based upon the ruling, every time you want to say something that is not a question to your witness, you're going to come up to the bench. So you do not get to say objection, blah, 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 and then wait for me to say to come up. You're going to come up. And this happened in the Hannah Gutierrez trial.
Yeah, just a point of clarification. I don't have any intention of approaching during the trial other than the rarest of circumstances.
No. You have to come up to the bench and put on the record your objection. You don't get to do it from there.
Okay. have to internalize this. I never had a trial conducted that way, so.
Wait, what? Every objection, they have to come up to the bench? He's shocked. He's like, I've never had this happen in a trial. What? I have to internalize.
I would ask to potentially address this issue. I mean, I don't think the defense or anything that I've done would necessitate changing the rules. At least I would ask them to.
This is, a court can do what they want with respect to objections, and this is what I'm going to rule. So I'm trying to, the sides have been contentious with one another. I think that you all may not intend to, but you might want to try to get the jury to see what's wrong with that question and or make some argument to try to influence the jury. And if you're going to object, it's going to be up here, and you're going to put on the record what the objection is, and I'll make a ruling up here.
May I just approach for just a second? So I'm glad I saved my rebuttal because I do want to address this issue, because I think that this system could disrupt the ability to cross-examine and disrupt the defense. It is not, as I think the court will acknowledge, it is true the court has great discretion. I think that deciding that before the trial even begins is an extreme use of discretion, just genuinely. I know that issue happened at the prior trial. I'm asking and urging the court to give an opportunity, at least to the defense, to just simply say, and I think my suggestion works, right? It's just objection, relevance. There's no other words coming out of my mouth ever during objections at a trial in front of the jury, and to allow us to have an opportunity to have what I would call a normal procedure. Because if every time there's any progress going on with a witness, they're standing up and they're making everybody come to the bench, they're disrupting the ability to cross-examine. They're disrupting the ability to put on our case.
Kills all momentum, especially from a juror's perspective. Like, imagine constant sidebars, like 15, 20 sidebars.
Many cases. I've never had that issue before. I've never had that issue with one witness in one case. So I'm asking the court to at least give the parties a chance to do it. I also am very concerned about the time, the schedule, and everything else. There are lots of objections that are just objection relevance. The court will rule. If the court needs to hear more, we come up. And I'm urging, almost begging the court to at least let us start that way, and then the court can, like this, and not hear from me further on this issue.
I'm not going to change my mind. I can see what I want to do is I want to start with you all getting the lay of the land. I'm going to be in control of the court. So this is what I'm going to do. I'm sorry that you haven't experienced this. It can happen, and it does happen. So that's what I'm going to do. If you all seem to be doing well and you get it, and I'm hearing relevance, then we can perhaps relax the rule. But that's how it's going to start off.
You just heard Ms. Johnson, in response to our arguments about the civil suits, say the civil cases are about October 6th to October 21st, the whole negligence. And that's very different from what Mr. Baldwin has been charged with. He's been charged with what happened on October 21st. And yet, when you look at the 404B disclosures that the state has provided, all of those disclosures relate to events that happened before October 21st. Mr. Baldwin swore on set. He cussed. And therefore, he committed homicide. Mr. Baldwin pointed the gun earlier, or rushed people earlier. And therefore, on October 21st, he had a propensity to do it again, or he committed homicide. That's exactly the kind of propensity evidence that must be excluded, Your Honor.
So he's going after the propensity side of things.
Mr. Baldwin swearing on October 16th is not a predicate act. It's not a crime at all. Whether he checked the gun or not on October 16th, not a predicate act. And so the cases that they cite have nothing to do with how they're trying to use the evidence here. Now, it might be different if they said, look at Mr. Baldwin on October 16th. Look what happened. He was rushing people. He was pointing the gun. He was doing all these crazy things on set. And look what happened. There was an accident. Someone got hurt on the 16th. And he knew it was dangerous to do what he was doing, yet he continued to act on the 21st in the same way, knowing that harm happened before. That might be relevant, but that's not what happened here. Because he swore at someone on the 16th or threw a gun on the ground on the 16th, they're trying to use it to show propensity. Reckless before, reckless now.
Alec got himself two pretty good lawyers. Trying to get rid of this propensity evidence is smart.
The evidence that they're trying to admit against Mr. Baldwin, it's all propensity. Mr. Baldwin's not a murderer on the 21st because he swore on the 16th. They're going to try to show that. That's highly improper. It should be excluded. Thank you, Your Honor.
The court allowed evidence of those medical records and allowed evidence of his application to get his commercial driver's license, where he indicated that there were no medical issues. And also, the court noted in allowing this as res gestae, or intrinsic evidence, that this evidence goes to the defendant's reckless state of mind. So for involuntary manslaughter under the state statute, as the court knows, the state has to prove that the defendant acted without due caution and circumspection. And so we have to prove criminal negligence, that the defendant willfully disregarded the rights and safety of others. For the state to only be allowed to introduce in a vacuum the moments leading up to October 21st, 2021, when the defendant shot Ms. Hutchins. However, intrinsic evidence allows the introduction of evidence that's inextricably intertwined with the acts that form the charged offense.
I would imagine the defense lawyer is going to say this isn't intrinsic evidence then.
These different videos show the defendant acting in a wanton and reckless manner. For example, there are 8 videos, and those are exhibits 61, 62, 63, 67, 68, 72, 74, and 76, where his finger is on the trigger when it shouldn't be.
Yeah, I mean, Alec's his trigger discipline was pretty terrible. There's like evidence of it being bad. But once again, he says he didn't pull the trigger. He pulled the hammer back.
Found with guns, exhibits 95, 111 to 115, and 65. Evidence of the defendant using the gun as a pointer, exhibits 91 and 58, are inextricably intertwined with what he did on October 21st when he pointed that gun at Ms. Hutchins, cocked the hammer, and pulled the trigger. As intrinsic evidence, these videos show on a number of occasions that this gun was working perfectly fine. It had no malfunctions. Every time the defendant fired it, he pulled the trigger. Are admissible under Rule 404B to show knowledge and to show lack of mistake. Knowledge in that the defendant should have known on October 21st when he was pointing that gun at Ms. Hutchins
He was aware of the risk. He's pointing a gun at someone.
that his conduct was wanton and reckless. And we prove that by the evidence of the other instances where he acted in a wanton and reckless manner as it relates to this gun.
The state told you what it's going to do. It's going to try to show recklessness before and therefore recklessness on October 21st. That's propensity evidence. That's not what Reggio allows, not what Kaufman allows, not what Lambert allows. They cannot do that by showing what happened before is an indication of what happened after. On top of that, most of the clips don't show Mr. Baldwin shooting. They show him swearing or putting a gun on the ground or taking a gun when he's lying on the ground instead of accidentally pointing it. These issues are not what they're trying to show about the 21st.
Alec was wilding on the movie set. What was he doing?
Evidence regarding defendant's handling or firing of the firearm or firearms firing during the filming of arrest are relevant in that they have any tendency to make a fact more probable, to wit that the firearm worked properly during the filming and that defendant Baldwin was not handling the firearm safely. Videos that show that he's cocking the gun when he doesn't need to cock the gun goes to the negligent use of a deadly weapon. However, everything else regarding him yelling at the crew or telling people to hurry up, none of that is relevant, and that is propensity evidence. So I think that you all can look at the videos, look at the any of those exhibits, and agree which ones meet my ruling. And if you can't do that, then I'll have to help you out.
Honestly, a pretty fair ruling. Any of the videos of Alec being a douche and yelling at people on movie set? No, but any videos of him with the gun looking like an idiot? Yes.
We do intend to argue that Mr. Baldwin didn't have subjective knowledge of a substantial risk to Ms. Hutchins' life because there wasn't a live bullet. In his mind, he didn't think there was a live bullet in the gun. You'll instruct the jury what they do with that, but that's certainly something we should be able to argue as to his state of mind. We won't tell the jury instructions. We won't tell them what to do. You will, of course, do that, Your Honor. And so you should deny the motion with respect to that issue.
The court finds that Robert Schillen's testimony regarding the Santa Fe County Sheriff's Office investigation as to what he saw and learned during the investigation is relevant. The state will present evidence of its investigation and how Mr. Baldwin came to be charged as a defendant for involuntary manslaughter.
Another relatively even ruling by the judge there.
They're trying to hold Mr. Baldwin responsible for what he did as an actor on the 21st because they claim he was reckless as a producer leading up to that time. That's a theory of vicarious liability in the criminal law that is not recognized. It's also far more prejudicial than it is probative because the jury's going to hear about what a producer does. They're going to hear about the producer being the boss, the buck stops with him, etc. And the risk is that they think Mr. Baldwin's responsible for what he did on the 21st because he's the boss, he's the CEO, he's in charge. But that's not a theory of liability, Your Honor. On top of that, there's no evidence at all, you won't hear any, that he hired Hannah Gutierrez-Reed, that he set the schedule, that he set the budget, period, full stop. Mr. Baldwin's role as a producer shows that he was keenly aware of the safety standards. Two issues with that, Your Honor. The state has said repeatedly in this case that Mr. Baldwin didn't violate the safety standards under Safety Bulletin number 1. He violated New Mexico law. They said that, page 29 of their opposition to our motion to dismiss the grand jury indictment. The fact that Mr. Baldwin was a producer is entirely irrelevant, highly prejudicial. It should be excluded.
Evidence that the defendant was a producer is relevant to demonstrate to the jury that he is aware of his safety obligations, the safety duties, and there will be evidence of the bulletin number 1, which sets out movie set safety rules and how Mr. Baldwin indeed violated those. I think what Ms. Morrissey indicated in her response is that he did violate New Mexico law, but to demonstrate that the defendant's conduct was reckless on set, the state is also going to introduce evidence that he violated these set safety rules that are in place for actors and producers to follow. Many state witnesses are going to testify that the defendant was the boss on set. What this is relevant to, it's relevant to his recklessness because we have to establish, again, it's not just in a vacuum, that the defendant's conduct on this set was reckless, and therefore, on October 21st, he should have been aware that his conduct of pointing a firearm at another human being, cocking that hammer, and pulling that trigger is reckless conduct.
Dude, the jury's in a hard position here. They're gonna have to try to decide this guy is responsible as the armorer for pulling that trigger on a movie set. He's an actor. I've been on sets of like music videos where there's prop guns and shit, and I've seen people like use prop guns. Like I've seen it. The actors don't be checking shit. They're just handed the prop gun. Like straight up, I've seen it. So I mean, I don't know.
It goes to the issue of the defendant's reckless state of mind.
You're referring to bulletin number 1. What are you relying on?
Well, there are a number of requirements as it relates to firearms. The actor and producers are responsible for the safety of others on set, for the safety of themselves and of others on set. That they are to treat a firearm as though it's always loaded. Do not point a firearm at another person. That is also it's for both, Your Honor. These are set safety rules.
But what about? So you're not even relying on that.
We are, Your Honor.
In your response, you said that you weren't talking about the SAE guidelines. You were talking talking about New Mexico law.
Well, Your Honor, I think that these are two different issues that are being conflated. So Mr. Baldwin is charged with involuntary manslaughter under New Mexico law. And how do we prove that? We prove that by demonstrating his conduct, not just on October 21st, but in the days leading up, that by violating these on-set movie set rules, that his conduct was reckless. Because it's not recklessness in a vacuum from...
You're talking about the gun, okay? So tell me what you think he did wrong as a producer.
So not just about the gun, Your Honor. So there are two, and that's why I wanted to address there. So there are two components here. So we have his conduct as it relates to the gun, but then his conduct as it relates to, for example, rushing the armorer to reload that gun. That goes to demonstrate his recklessness. There's no regard for the safety of other people. When you're rushing the armorer to reload this firearm, mistakes can happen. And so with regard to his producer role, there is evidence that will be presented that Mr. Baldwin should be aware of all of the safety regulations.
So I did have trouble wrapping my head around this, as you can tell, okay? So the jury's going to hear this and they're going to go, well, Mr. Baldwin was the actor that was rushing, but he was also being a producer at the same time.
It could get a little confusing with this, yeah.
Your Honor, because it goes to the recklessness. So he is a producer, and his contract states he's also the leading actor. So he's got a dual role, and with both roles, he fails in maintaining the safety of other people. See, what the defense is trying to do is just basically pigeonhole Mr. Baldwin as just an actor who relies on everybody else, and he relied on this armorer to not give him a gun with a live bullet. But his role as a producer requires him, there are more duties imposed on him as a producer. And those duties include, and there's expert testimony that will be presented, that his duties as a producer...
Okay, I don't understand how you're going to say as a producer, he shouldn't have, as an actor and a producer, he shouldn't have rushed, he should have said, quick, move.
Well, but...
Obviously, rushing an armorer is bad because they're reloading your gun and they could up, and it was a young lady, so she's not very experienced. Is there a movie set in the history of time that isn't rushed? Every movie set in the history of time, there's someone on that set rushing people. They have a set schedule, they have a budget. I'm pretty sure that's even someone's job, is literally just to make sure everything is going well.
Shouldn't have done that. But also as a producer, Your Honor, he is the boss. And as the boss, he is responsible for the safety of other people. So it goes to his state of mind, his willfulness. And there was a tremendous lack of safety on this set.
Which I agree with. It was there were other people, like crew members, that left because they felt like it wasn't safe. So it was definitely some unsafe shit.
With respect to the first negligent use of a deadly weapon, okay? That's not the producer. That's the actor.
That is the actor, but he's also charged in the alternative. It's more than that.
Well, that is what was given to the grand jury. That he failed to check the gun and pointed a loaded gun at a person.
Yeah, this is so tricky. I mean, if I'm an actor on set, with how many takes they do, and it was like rehearsal, am I gonna check the gun every time? I don't know. I just wouldn't point it at anyone, honestly. I'm not an idiot.
Your Honor, I hardly know where to begin because I honestly don't understand the theory or the facts that they intend to articulate to demonstrate that on October 21st, Alec Baldwin, the actor, committed involuntary manslaughter. Well, the safety bulletins explain that. Two things. Number one, they already said in their response that the safety bulletins were violated. New Mexico law was. Number two, look at those safety bulletins carefully. I'm sure Your Honor's read them many times. They say nothing about the producer not pointing the gun. They say the exclusive responsibility of gun safety is on the prop master, the armorer, the first assistant director. Doesn't say anything about a producer. There are a number of actors doing the same exact thing that was required by the safety guidelines. Those are SAG guidelines for actors, armorers, first assistant director, and the prop master. They say, well, maybe it's because Mr. Baldwin was rushing before October 21st, and as a producer, I'm not sure what that distinction is, producer, actor, and therefore on the 21st he was. But you just excluded the evidence of him rushing because that's propensity evidence. That's inappropriate. We're so confused about what the theory actually is. It goes directly to the prejudice that will far outweigh the probative nature of this testimony. They want to show that he's the boss, and therefore on October 21st, as an actor, he committed involuntary manslaughter. That is highly prejudicial, inappropriate evidence that should be excluded.
So what I think is more appropriate is I'm going to revisit this, make my ruling, no more argument on it, but I think that we should do
The state intends to offer Mr. Jorgenson on two issues. One is the role of a producer in managing the safety of the set, and the second is the safety bulletins that govern actors on movie sets. Mr. Jorgenson should be excluded. First things first, on the evidence of producer, his opinions on producer. Mr. Jorgenson has never been a producer in his life. He was a camera grip back 25, 30 years ago. Never been a producer. We asked him, what is the basis for your testimony as to what producers do?
Why didn't the state just go find a real producer? Someone with experience with guns on a set. Why would the state do this?
On a movie set. He said, well, it's because I get to sit at the kids' table, these are his words, and listen to the adults talking. Your Honor, this is not the kids' table. This is the adults' table. Mr. Jorgenson has absolutely no expertise, and sitting at the kids' table doesn't allow him to sit over there and give testimony about what it is a producer is required to do on a movie set in a criminal trial on involuntary manslaughter. With respect to the safety standards, Mr. Jorgenson didn't draft the safety standards. He's not a gun expert. He was a camera grip. Sets up camera angles and scaffolding, etc. He is not a gun expert. He's not an armor. He's never been a prop master. He's never been a first assistant director with the safety obligations. His role, as he described it, is administrative.
Your Honor, Mr. Jorgenson teaches producers about their responsibilities with regard to set safety. He's going to take the witness stand. He can outline his experience.
So he's a teacher. He's just never done it. All right, interesting.
I am not calling Mr. Jorgenson so that he can come and just generally talk about this is what a producer does. I am calling Mr. Jorgenson to come in and talk about the producer's responsibility with regard to set safety. And Mr. Jorgenson is acutely familiar with this because he actually teaches producers what their responsibilities are and how they can have a safe set and avoid getting sued for killing someone. This safety bulletin says, don't point a gun at anyone. Keep your finger off the trigger. Assume that anything that you point the gun at will be destroyed.
So if he's going to testify to just shit like this, I think it's fine for him to come in. She said she's not going to ask him questions about what a producer does, experiences like as a producer. Yeah, it's just about safety bulletins and shit.
Probative value not substantially outweighed by unfair prejudice and certainly confusion of issues to the jury. So I'm denying evidence of his status as a producer. All right, shall we continue?
Many people, like many jurors, are not at all familiar with safety protocols on movie sets. And many of the state's experts are being called to educate the jury with regard to safe practices in movie sets. On the Jorgenson motion that we just went over, Your Honor, let me read from that one too. Safety bulletins and protocols on the use and handling of firearms on a movie set, as well as movie production requirements to ensure a safe working environment, are not within the average layperson's knowledge.
So they shot themselves in the foot. They're trying to get lay witnesses to talk about scientific shit, but they've already admitted that a lot of lay witnesses don't know.
Knowledge, expert testimony. They try to get experts in on it, but then they try to say it's just lay opinion testimony that the medic can offer, the camera grip can offer. They cannot have it both ways, Your Honor. And in fact, Vargas reversed a conviction when the court allowed that evidence. That was a police detective who was allowed to testify about his experience with a stun gun.
These are not people who are being called as experts to come in and talk about set safety. These are people who are going to come in and say, we had safety concerns on this movie set because we knew from our experience, and by the way, this gentleman was the most experienced person on set, Mr. Baldwin. So if these other folks who had slightly less experience than him had concerns,
Miss Morrissey coming back swinging.
Ms. Gutierrez was doing her job properly, this is the way that the state gets to combat the defense. There was absolutely nothing wrong with her. She was an amazing, stellar professional. This court knows that is absolutely untrue. So it is perfectly appropriate for lay witnesses to come in and say, I've been working on movie sets for the last 15 years or 20 years, or in Mr. Baldwin's case, 40 years. And I know exactly how these safety protocols work. And here's what makes it a little bit unique on a movie set, is that the safety protocols that take place between the armorer and the actor and the first assistant director is this thing that happens out in the open, where the armorer says to all of the crew members, all of these people who are going to come in and testify, hey, does anybody want to see the rounds? Does anybody want to come and see me load the gun? Because you're the people who are standing potentially in the way. So all of these crew members actually get to participate in the safety check.
A lay witness can testify if rationally based on perception, helpful to clarifying an understanding of the witness's testimony or determining a fact and issue, and is not based on scientific, technical, or other specialized knowledge. Particularized knowledge is acceptable here, although I don't find it here on what they intend to do. Lay witness testimony of what they observed on set, providing that it's relevant. What they observed on set, in this set, and what they observed on other sets, provided that they have a sufficient history to do so. However, we're going to have to decide relevance.
Yeah, that's pretty much it for the pretrial hearing. This trial's about to start tomorrow, so I'll try to cover it over the next 2 weeks. I think it's going to be like a 2-week long trial, so subscribe. Love you guys. Peace out.